My name is Dave Gonadev. Okay. Yeah, got it. Just before we start the meeting, Judge is asking us to have a few moments of private time. Can I excuse the rest of you for the public members?
Oh, no, everyone can stay. I'd
Okay.
just like to speak for a moment just to the panel.
Judge, yes, it's yours.
Good morning. We're going to not yet be on the record. I'd like to just speak with the panel members for a moment about our procedure. If we can just talk for a moment. Okay, just come. Actually, we've spoken. We're off the record? All right. Thank you. Thank you. I'd already spoken, it's just that we
Oh.
Panel B, meeting to the order.
I cannot hear, sorry.
Microphones are not here.
I think it's ready now.
Okay. We're on, right? Okay, thank you. This is Panel B meeting, Medical Board of California. Roll call, please.
Here.
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 I cannot hear, I'm so sorry. I can't hear you.
Use the microphone, please.
Oh, I'm sorry. Morning. Dr. Kraus,
Here.
Dr. Levine,
Here.
Ms. Pines,
Here.
Ms. Shipsky, Mr. Tagami, Dr. Gonadev.
Here.
We have a quorum, thank you.
Thank you.
So,
Dr. Levine.
I think our first order of business is to elect a chair and vice chair for Panel B, and I'd like to nominate Dr. Gonadev as chair and Ms. Pines as vice chair of Panel B. I guess.
Second.
Any objections? Thank you. Thank you.
Thank
I
you.
appreciate it. I'm trying to bring up my first order of business. Computer is taking forever. Judge, that.
Oral argument? Is it now for me? My turn?
Yes.
All right. Good morning. My name is Beth Faber-Jacobs. I'm an administrative law judge with the Office of Administrative Hearings. And I'm going to now call the cases for oral argument. We are here for oral argument in the board's non-adoption in the first amended accusation against Robert Markman, MD. It's Medical Board Case Number 17, 2011, 214399. I've been assigned to sit with the board for this proceeding and preside over today's matter. Today is Thursday, October 24th, 2013. It's about 8:40. May I have the appearances starting with counsel for complainant?
Yes, Clint James McKay from the Attorney General's Office for Complainant.
Good morning, Mr. McKay. And Dr. Markman, you're representing yourself in this proceeding?
Yes.
All right, sir. Before we begin, there's some information that I'd like to give regarding my background and my role in this proceeding. As you know, Mr. McKay is in the Attorney General's office. I worked in the Attorney General's office for many years And for a number of those years, I was in the health quality enforcement section and knew Mr. Mackay, although we were in different cities. I have not spoken to anyone in the Attorney General's office concerning this matter, and I have not spoken to the board concerning this matter, and in fact, I have not met the panel members at all until this morning. I have a very limited role in today's proceeding. I am not the decision maker. The board will be making the decision, but there may be some legal issues that I will be called upon to rule on. I believe I can be fair and impartial and provide a fair process to both parties, but I wanted to give you this information before we proceeded. Are we ready to proceed?
Yes. We are.
All right. As you've previously been advised, each party will have 15 minutes to present your oral argument, and then each will have 5 minutes for rebuttal. Dr. Markman, when a person who's not represented makes an appearance before the board, we usually swear them in. So at this time, I'd like you to stand, and I will give you the oath. Please raise your right hand. Do you solemnly swear, under penalty of perjury, that the argument you'll be giving in this proceeding today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Thank you, sir. You may be seated. And normally we start with the licensee. And Dr. Markman, would you like me to give you a few minutes notice before the 15 minutes are up?
No, I have a timer right here.
All right, and if you'll give me one moment, you may begin.
First, I want to thank you for stopping the insanity. This is an unprecedented case. My daughter has been battling pain for 19 years, almost half of her life. Before I started treating her myself, I pursued all possible treatment options. It was only after every intervention failed that I began to administer propofol to her. Expert physicians from every conceivable specialty have attempted to help her, but the results have been disastrous. She was hospitalized in 2008 for acute hepatorenal failure following the embolization of her ovarian veins. In 2009, she developed a severe MRSA cellulitis and abscess following the implantation of a sacral nerve stimulator, and that complication kept her bedridden for almost a year. Since 2010, she has been bedridden as a result of the permanent damage done to her sacral nerve roots and pudendal nerves as a result of the overzealous use of radiofrequency treatment. These last two complications were not only iatrogenic, they were a direct result of the negligence of two internationally renowned experts, Dr. Shlomo Raz, urologist at UCLA, and Dr. Sheldon Jordan, neurologist and pain specialist, also from UCLA. As a result of these medical misadventures, 4 years ago, my daughter became almost completely bedridden to the extent that even the slightest movement in her bed caused excruciating pain. You've seen the video. I have stills here for you if for anyone who hasn't seen the video. Would anyone like to see the stills from the video?
Any panel members like to see? No, thank you.
Okay. Out of necessity, I came up with an innovative way to relieve my daughter's suffering. After studying the laws that govern the practice of medicine in California, and after consulting with the DEA, I found that I could administer propofol to my daughter in my home without violating any state or federal statutes. Then I developed a protocol guaranteeing my daughter's safety, and the propofol turned out to be amazingly effective as a form of palliative treatment. It worked so well that I submitted an abstract to the journal Anesthesia and Analgesia describing my results so that other anesthesiologists interested in helping patients with intractable pain could learn from my experience. It worked so well that my daughter's life became bearable. When she had access to propofol, she had a life and she had hope. She was able to take a flight to New York and spend a weekend at a Lyme disease conference. She was able to leave the house and take a 12-hour round trip with me to Stanford's pain clinic. and 3 separate 6-hour round trips with me to see Dr. Goldstein in San Diego. Since the medical board took the propofol away, her life has been unbearable. She gets out of bed only to sit on the toilet for hours, and now it's a struggle for her to make the 15-minute trip to her pain doctor in Encino once a month. 19 months ago, in one stroke, the medical board suspended my license and publicized worldwide what it had done. I was instantly vilified as the next Conrad Murray, stopped just in time. The world was put on notice that the state of California was not going to tolerate the use of propofol, the drug that killed Michael Jackson, for anything but anesthesia or sedation in licensed facilities. No matter that it had been safely administered to over 1 billion patients, 15,000 of them my own patients. No matter that I had developed a way to administer propofol at home that is safer than hospital administration. No matter that is the only treatment that allows my daughter to have some quality of life. I was declared an imminent danger to my daughter, and she has suffered from that decision for 19 months. What the board has done is to severely harm my daughter in the guise of protecting her from the infinitesimally small chance that I might harm her. The concept that the medical board can itself cause unlimited harm in order to prevent the possibility of harm is a perverse concept. The harm done by this medical board is not just physical harm, and it's not just harm to my daughter. If I hadn't been interrupted by the medical board, the abstract I submitted for publication on propofol would have been revised and published by now, and my findings duplicated by other physicians. It's no accident that 2 days after I sent a letter to Linda Whitney calling into question the integrity of the medical board investigation, that 2 detectives from the LAPD Sexual Assault Unit arrived at my house demanding that I wake my bedridden daughter up and drag her outside. When I refused, they yanked me off my porch, threw me to the ground, punched me in the face, arrested me, and charged me with assaulting a police officer and delaying a police officer. This was all engineered by Mr. McKay. Those 2 LAPD detectives were sent by Mr. McKay. Even though I was acquitted of assault after a jury trial, it hasn't stopped Mr. McKay from repeatedly to this day claiming that I attacked and injured 2 police officers. If you dig deep enough into the record, this is obvious. During the interim suspension order hearing, Mr. McKay repeatedly told Judge Juarez that
Dr. Markman, your argument needs to be about the decision.
I wish
and
you wouldn't interrupt me, because I've watched these hearings and the interruption, there were no interruptions. One of the attorneys representing the state made some remarks that were not part of the record, and the ALJ who was presiding waited till the end in both instances and then said, well, this will not be on the record. So I wish you could do it that way. I'd appreciate it.
This will apply to both you and to Mr. McKay.
Okay. Mr. McKay asked, this is relevant, and you won't see unless you let me, complete a couple more sentences. That's why I wish you wouldn't interrupt me.
You may complete a few more sentences, but I encourage you to stick to the propriety of the decision and to what oral argument is supposed to address today.
I am sticking to it, but you're not letting me even.
You may continue.
I mean, you stopped me way too soon.
Oh, you're
I'm
not
sorry.
stopped. You may continue,
Well,
sir.
you're taking away my time, and I don't appreciate that either. It's
I will-
15 minutes. It's really hard to say what I want to say in 15 minutes. At the interim suspension order hearing, Mr. McKay repeatedly asked Judge Juarez to issue an order so that he could have my daughter forcibly removed from my house. But Juarez didn't make that order. That didn't stop McKay. My daughter will never recover from the trauma of the police first coming to take me away and then coming back 3 months later to take her away. She'll suffer from severe PTSD until the day she dies. She has suffered tremendous physical and emotional harm as a result of this abuse of power. Mr. McKay, of course, denies he was responsible for this attempted abduction of my daughter, but again, if you dig deep enough, the evidence in the record is clear. Mr. McKay's arguments to this panel rely on allegations that have all been proven false at the hearings. His tactic of repeating lies until they become facts may work well with poorly trained judges who have no business deciding medical issues, but I'm confident that this panel will see through them. The state did not show that it is safer for my daughter to be treated in a licensed facility than to be treated by me with no backup in my home. It actually inadvertently, convincingly proved just the opposite. I watched with great interest your last meeting where the Deputy Attorney General argued against allowing Dr. Ryan Peterson to return to practice as an anesthesiologist because the oversight at surgery centers would likely not prevent an operating table death.
Sir, let's talk about if you could restrict your argument to your case. I will give you a little extra time for these interruptions, but please direct your argument to the case, to the decision that is before the board now.
This is part of my argument. If you'd give me a chance, you would see it. Dr. Peterson, a meth addict for 13 years, was injecting himself with fentanyl and propofol undetected while providing anesthesia in licensed facilities. How many patients did he put in danger despite practicing in licensed facilities? The medical board is making a big deal of the fact that I didn't provide the propofol at a licensed facility. The oversight at licensed facilities admitted by by one of the medical board's own deputy attorney generals at the last hearing that some of you were at, argued that the oversight at these facilities is not going to prevent a death. The risk of harm to my daughter from being treated at surgery centers or hospitals has been empirically proven more than once to be much greater than the risk of me treating my daughter at home. At home, she doesn't have to worry about drug-addicted anesthesiologists or nurses' mistakes or the infections like the MRSA infection that she got and that are common in hospitals. More than anyone, my daughter understands the risks of being treated by the experts in their licensed facilities. At this point, she would rather die than live the way she is living, and she has vowed never to return to a hospital again. She would like you to accept that unless a miracle cure comes along very soon, that she is dying, and all she wants at this point is for the medical board to allow her to receive the care she chooses. My daughter and other patients who suffer from persistent genital arousal disorder have said that they would rather have cancer than the persistent genital arousal disorder because at least cancer has an end. Although Lisa has told me that she would never consider suicide, she also has told me many times to give up on her, that in fact, after battling pain for half her life, she would welcome death. Dr. Schaefer wrote a letter to Judge Formaker 19 months ago stating, quote, "This misrepresentation by Mr. Mackay is so offensive that in my view, Mr. Mackay should be barred from further future representation of the Department of Justice for the state of California. Mr. Mackay has demonstrated an utter disregard for honest representation of the interests of the state. I am shocked, disappointed, and frankly disgusted that Mr. Mackay, representing the Department of Justice, has chosen to repeatedly misrepresent the facts and distort the care and the intent of Dr. Markman."
Dr. Markman, this is not about the Deputy Attorney General. Please proceed with argument regarding your matter.
The Deputy Attorney General produced fantasy instead of facts, and that is about, it's up to you to decide whether it was fantasy or facts, so I don't see why that shouldn't be part of my argument. I didn't ask Dr. Schaefer to write that amicus brief. He insisted on writing it because he strongly believes that what the medical board is doing is wrong. Mr. Mackay wrote that the panel should disregard the what he calls the purported amicus brief. He claims there's no provision in the board hearings for testimony and arguments by third parties with no interest in the matter. Really, Mr. Mackay, why does Mackay pretend that Code Section 1364.31A doesn't exist? And I'll quote it here. "A non-party with an interest in the outcome of an administrative hearing may be permitted to file an amicus curiae brief when a panel has non-adopted a decision." Mackay pretends this doesn't exist because Dr. Schaefer's amicus brief is devastating to the medical board's case against me. Mr. Mackay repeatedly makes false statements to conflate facts with fantasy, like the following list of completely false statements, and these are quotes from him. He attacked a social worker. He attacked 2 policemen. He injured a police detective. He physically fought with police who were attempting to monitor him. He attacked an adult protective service investigator. He was injecting drugs into her clitoris and labia. The house is entirely filthy with rotting food in the treatment area. There are blow-ups of Lisa's genitalia tacked to the wall around Respondent's workplace. What I have here is the only picture of genitalia that was ever tacked on any of my walls. And as you can see, it's a picture of my daughter fully clothed with her dog's penis showing. Those are the genitalia that he claims are my daughter's genitalia.
Sir, if you can please take the picture back to the table.
My daughter wanted to be here, so she could be sitting in the audience, but I brought a picture.
That is not evidence that we are relying upon in this proceeding. Please restrict your comments to the record. And for the record, the comments regarding Mr. Mackay are not the evidence in this proceeding. Your time is almost up. I will, as I said, I would give you an additional minute for the interruptions. That minute is now beginning.
Here are more lies by Mr. Mackay. His daughter has a long history of drug use and mental illness. He has utterly failed to consult with pain specialists. He didn't allow his daughter to be treated at Stanford. These statements are all 100% untrue. There's no evidence of any kind that, for any of these things that were produced at the hearing. Mackay's written argument consists of 14 lies and 7 pages. His reply brief consists of 26 lies and 4 pages. His most malicious lie is, nonetheless, without corroboration, Respondent himself diagnosed his daughter with persistent genital arousal disorder. That is so untrue. She was diagnosed by Dr. Berman at UCLA originally, and that diagnosis was confirmed by Dr. Glazer, Dr. Roz, and Dr. Goldstein, who has been treating her. For him to make a statement that I diagnosed myself that disease so that he could keep his narrative that I'm some kind of pedophile pervert who's locked his daughter up in his room so he could examine her genitals is malicious. It's just malicious, and he should not be representing the state of California. Dr. Schaefer is an esteemed professor at Stanford and Columbia, and he is so enraged by what he saw and the way Mr. Mackay performed that he, on his own, wrote that amicus. I didn't ask him to.
Dr. Markman, your time has concluded. You'll have 5 minutes to do your closing argument after Mr. Mackay has his argument. Thank you. Mr. Mackay.
Thank you. Let's start by talking about just what we know. What happened here is that Dr. Markman took his daughter to Cedars-Sinai and told them the treatment that he was administering to his daughter. They were so concerned about it, they reported him to the medical board. That's how this began. In the course of that investigation, Investigator Hollis and I went out to the house, and personally, I walked in, Investigator Hollis walked in, smelled the place, saw dog feces, saw all of this going on, interviewed his daughter. I was present, Investigator Hollis was present. We interviewed his daughter, who was in a room, cluttered, you can't even move in the room, sitting in a bed. He then, Dr. Markman, then escorted us to his treatment room, which is in his bedroom. His bed, then a treatment gurney with little fuzzy slippers on it, not making this up, where he treats his daughter. In that room is an array of different equipment, an array of different drugs, some of which have been expired 15 years. He has created a treatment, basically a surgery room, administration room, if you will, in his bedroom. The equipment which is in there, some of it has been accumulated by him, some of it has been built by him, including a cigar box that has 2 little holes cut in it to prevent his daughter from increasing the propofol dose while she's getting these treatments, which he brought to trial and showed to the judge. We know then that at trial we brought in 4 experts, one of whom, Sean Mackay, is an undisputed expert in pain management worldwide. Even Dr. Markman's expert, Dr. Schaefer, conceded that Dr. Mackay is a preeminent pain management person. By the way, Dr. Markman is not. He's an anesthesiologist. He may have administered propofol. He is not a pain management person. When we inspected the house, by the way, Investigator Hollis testified, and I personally also saw pictures of his daughter's genitalia on his desk. She testified to that at the hearing. I put that testimony in my brief. You can read that. That's what we saw. It's undisputed that he examined his daughter's genitalia multiple times, purportedly in the course of treatment. We went through, brought in 4 experts, had them review it. Dr. Mackay, as I said in my brief, indicated that the treatment that Dr. Markman was administering to his daughter was multiple standard deviations from the practice of medicine in California, the proper practice of medicine in California. Dr. Verdelin, Dr. Macbeth, Dr. Penhallow, we had 4 experts talk about these issues. What he is doing here is he's experimenting on his daughter. If we just take as fact that what's going on here is some innovative treatment which he himself has developed, that he himself is the only one, he's the smartest man in the room, he's the only one who has seen that this will in fact act as an analgesic for his daughter's pain. If we take that as given fact, what he's doing is experimenting on his daughter in his bedroom of his house. Now, an Adult Protective Services worker went out to the house to make sure she was okay. He chased her into his car. Okay, she had to lock up the windows. Thereafter, 2 officers come to the house. They try to see her. They end up in a scuffle. He ends up being convicted of interfering with a police officer and does time in jail for that little activity. This is not the practice of medicine, okay? This is not the standard of care in California. Now, with respect to Judge Cohen, the decision which he administered, which he proposed decision, provides for probation and for a monitor, but to allow the treatments to continue in his house. Now, you yourself have now heard the degree to which he respects the medical board. You have heard the degree to which he believes that he is right in this situation. How much do you think he will cooperate with a monitor that will be placed in his house? This is going to be a game of cat and mouse. A monitor will be appointed. Probably, if it's an independent monitor, he will try to do his job. If it's a friendly monitor, friendly to Dr. Markman, there will be no monitoring as such. In either event, what will happen here is that the treatments will continue. He will begin to administer propofol, which, as we know, is a dangerous drug. He already acknowledges that he's given it to her 500 times. 500 times he's administered propofol in his bedroom on the gurney with the fuzzy slippers. This in itself, aside from the expired drugs, aside from the cigar box with holes cut in it, aside from the filth that was in his house, and by the way, he apparently did clean it up when his experts inspected it. Did clean up his house, so when his experts came out there, it was clean. When the investigator and I went out there, it was not. Okay, so we can imagine the normal condition of this place. Okay, but nonetheless, the monitor that Judge Cohen proposes is simply not going to work either way. It's either going to be a friendly monitor, in which case Dr. Markman will get no monitoring, or it's going to be a truly objective monitor, in which case he's going to fight him every inch of the way. Everything he can do, he will do. There's no doubt. There can be no doubt, watching this man, the way he talks, that he's not going to cooperate with a probation monitor. He's not going to cooperate with a practice monitor. It's not going to happen in real life. Now, there was an argument that Dr. Markman was supposedly the physician of last resort. But in fact, Dr. Mackay indicated that she could be evaluated and treated at Stanford Payne, which was one of the foremost clinics in the country. Now, one of the things they said they would do there was they would clean her out. They'd stop her drugs. They would try to diagnose what in fact was going on with her, rather than having her father trail around behind her to all these different doctors and trying to manage, trying to interfere, trying to control her treatment. They would close all of that off, clean her out, and let's see what we got. Makes sense. We don't do it at Stanford Payne. We could do it at UCLA. We could do it. There are a number of different excellent pain management clinics in this country. None of that is going to happen as long as this man is allowed to continue to treat her. That's the truth. Because he is the smartest man in the room, as you have heard. Now, in this situation, you have a woman who had been at least 150 hold, has a variety of physical illnesses. We don't know, because we've never actually had an independent assessment done by a pain management clinic such as Stanford, what the interaction is between the various drugs and the physical ailments that have actually preceded this whole onset of all these different treatments and stuff, and which were caused by the treatments. We have no idea, because there's going to have to be a full evaluation, which the two of them will not allow. They're not going to allow that to happen. They didn't go back to Stanford, okay? They're not going to go back to Stanford. What's going to happen here, and I'm sorry, my phone went off, so I don't know how much time I have. How much time do I
You
have?
have about 6.5 minutes.
Okay. What's going to happen here is that things are going to proceed the way that they have proceeded. Now, Dr. Mackay, I put in my brief some of his comments regarding these treatments. Dr. Verdelin, Dr. Macbeth, and Dr. Penhallow were saying the same thing, okay? The only expert, pain management expert, who testified about the use of propofol and all of this analgesic stuff was Dr. Schaefer. Now, I have no idea what the relationship is between Dr. Schaefer and Dr. Markman. Apparently, he submitted a paper to him. He's trying to get him published or whatever it is. But there seems to be some type of relationship there where somehow Dr. Schaefer has bought into these arguments. But every other physician who has looked at this situation is appalled. I mean, it's not surprising. I mean, excuse me, but it's not brain surgery, right? Some of you may be brain surgeons. I apologize if I'm saying that. But I'm just saying that what happens here is just taking a look at what we know, which is that you have a father treating a daughter and contending that he is objective. Now, if you take him at his word and you say that this young woman, and she's 37 now or so, is suffering from unbelievable pain, just take that as a given. I don't know of any parent who could be objective, could objectively decide, oh, here's the best treatment plan for this person, when in the next room, this person is in pain, is in agony, is howling and saying, I can't stand it, I don't want to live anymore. It's absurd to contemplate. It's absurd to think that this man can objectively treat his daughter. Then you move on to the fact that he's treating her in his house, in his bedroom. You go on to the fact that he's examining her genitalia. You go on to the fact that the place is dirty. You go on to the fact that there's no independent oversight of any of these treatments. That it is far outside, not just outside, not just, well, let's just talk about it, far outside any kind of current practice, current treatment that is acknowledged in the medical community. Now, in the event that propofol down the road is found to be an analgesic, an effective analgesic, that kind of treatment will be given in a hospital where there are nurses, where there are people who oversee the situation, where there are backup in the event something goes wrong. We know what happens when propofol is administered and there is no one at home or there's something goes wrong. We know this. Okay? This situation is so far out of anything that should be permitted by the medical board that it's almost beyond argument, but apparently it's not. Judge Cohen's primary fault, in my view, is being too optimistic. He felt that somehow this could be managed. I'm telling you it can't be managed. I'm telling you that there's no way that this man will allow it to be managed, because he is the one who knows best. That is the situation. With respect to PGAD, whoever diagnosed it, understand there are only 22 diagnosed cases in the history of recorded medicine. 22. Whole world, 22 cases. But apparently there's one here in Los Angeles now. If that's true, there's even one more reason why this young woman needs to be seen by a multidisciplinary team who can evaluate her for drugs, for physical damage, physical ailments, for this syndrome, which apparently there's some feeling she might have. That's what's required here.
You have 2 minutes left, sir.
Thank you. Not treating her by her father in his bedroom, next to his bed, in a house which Investigator House testified at the hearing is filthy. This is not modern medicine. Thank you.
Thank you, sir. Dr. Markman, you have 5-minute rebuttal. Would you like to do your rebuttal?
Yes.
All right.
The only fuzzy thing, and there were no fuzzy slippers, is Mr. McKay's fuzzy logic. As far as the feces, the only feces is what's coming out of Mr. McKay's mouth. There's never any dog feces in my house. That is just, as everything else he said, a lie. He has a gift to sit here and look you straight in the face and lie. And if you have read, and I hope you have, my 47-page written argument that cites every fact and every lie, then you'll know that he's lying. But if you go ahead and check anything he says with the record, you'll find out that everything's a lie. I did know jail time. I don't have a cigar box. I have a safe. I bought a safe and cut holes in it so the IV tube can go through it. This idea that there's 22 cases of PGAD in the history of the world is nonsense. If you look at Mr. McKay's favorite reference, Wikipedia, it says there are 7,000 cases worldwide. The problem with Mr. McKay's experts is PGAD is not a pain disorder. It's a disorder of constant arousal. Arousal that is not relieved by orgasm, ever. It's like my daughter's been in a state of constant arousal for the last 7 years. And it is not pain, it's something that cannot be, it's just different enough that pain specialists have no idea what to do. No pain physicians have ever written anything about PGAD. There are other doctors that have. There's obstetricians, gynecologists, there's surgeons, there's Dr. Goldstein who's seen my daughter 3 or 4 times and has actually taught me how to do pudendal blocks on her because he has his own technique and he understood that she is bedridden and can't keep going back and forth to San Diego. He understood that it made sense for me to give her pudendal blocks in my house. And this idea that she purportedly has it is nonsense. I listed 5 doctors that have diagnosed it. And this idea that Dr. Mackay, that my daughter and I have not gone back to Dr. Mackay for a full evaluation. Look at the chart. Look at the second time we went there. She was fully evaluated. His whole story is just full of holes. There's nothing but holes. We went back to Stanford a second time. My daughter was fully evaluated by Dr. Mackay, and she is following all of his suggestions. Unfortunately, he doesn't have any magic medicine, and he doesn't have any. If you look at Exhibit 5201, I believe, that's a second visit. That's a full evaluation by him. And aside from that, Dr. Mackay, I can quote his first impression was that I am not. He said that Dr. Markman, as far as I can tell, is not putting his daughter in any danger. And that is, he wrote that. Everything that Mr. Mackay, I can't stress this enough, is a lie. If you read the 47-page written argument I made, you'd know that. If you haven't read the case, then how do you know what's true? If you've actually read it and have been diligent in it, and I trust you have been, and read Dr. Schaefer's amicus brief, then you know that this guy is a fraud. He's a total fraud. He should not be sitting here in front of you. He's a disgrace. And you should not have lay judges and lay attorneys deciding cases that involve medical testimony that they cannot understand.
You need to wrap up your argument now, sir.
So I'm not interested in you deciding that I need to have some kind of discipline. I'm interested in getting my license back without any restriction so I can take care of my dying daughter without any further interference from you. You've done it. I don't mean you. Let me say this. Mr. Mackay has disdain for all of you because he just comes up here and lies. I highly respect this panel because you have made, you realize there's something wrong with Judge Cohn's decision. So I highly respect that you did that and took the time hopefully you took the time to read over the record and you realize what's going on here. My daughter needs my care. I am the doctor of last resort. Everyone else has given up on her. Every treatment has been tried. He keeps talking about Dr. Mackay.
Dr. Markman,
Dr. Mackay has nothing to offer.
thank you for your argument. Mr. Mackay, rebuttal?
Thank
You may proceed.
Thank you. The fact of the matter is if anything has been demonstrated here today, it's that he has no objectivity. He has none. Whatever treatment there might be, however many different therapies have been tried, he has no ability to assess the true nature of his daughter's ailments, what a treatment is appropriate, and to administer that treatment. If this man has his license back, he will do exactly what he wants to do. Make no mistake, he will. And that is because he believes that what he is doing is right. And he doesn't believe that anyone else has the right to tell him differently. He thinks that he has gone through all of this stuff and he knows. It is important that that be seen as the seminal point here, is that whatever you say to him, if you allow him to practice medicine, he will do exactly what he wants to do. Monitoring isn't going to help. Probation isn't going to help. Nothing will help other than revocation. That's the only thing that will solve this problem. This is mental illness. This is an interlocking mental illness. This is not medicine. And there's nothing that you're going to do that's going to be able to control it other than revoking his license. Thank you.
Thank you, sir. At this time, the matter will be submitted. The board will be going into closed session. We thank everyone. Excuse me, doctor.
I wanted to see if any panel members have any questions to Dr. Markman or Mr. Mackay.
Thank you. Are there any questions from any of the panel members? Yes, Dr. Levine.
Dr. Markman, just to be clear, at the time your license was suspended, What treatments, were there any treatments beside the propofol that were being administered by you to your daughter?
Yes, I was doing clitoral nerve blocks and pudendal nerve blocks.
And how often?
They were being, well, it is complicated because they were effective. The blocks were effective for about up to 2 weeks at a time until Dr. Jordan started doing his radio frequency. In fact, I took her to Dr. Jordan so that he could do something that would last longer than Marcaine blocks, because I was getting a week to 2 weeks out of them. He said he could get 6 months by treating her pudendal nerves. He would be able to block her discomfort for 6 months. But that didn't work that way. The first time he did it, it blocked it for 10 days, and then it came back worse than ever, and he did it 6 times, way too many times. As Dr. Mackay testified, it was negligent, and it was malpractice, really. But every time he did it, she would get relief for a shorter and shorter period of time, and my blocks became less and less effective until I finally stopped doing them, because after he'd done the radio frequency treatments 6 or 7 times, and she was in much worse pain than before I had ever taken her there, my blocks didn't work anymore. Whatever he'd done to the pudendal nerve, my blocks wouldn't work anymore, and I stopped doing them.
So you had stopped doing the pudendal
Yes.
and clitoral nerve blocks. And was she taking any other medication at the time your license was suspended?
Yes, she's taking the same medication she takes now. She's taking narcotics. She's taking Exalgo, or it's a long-acting Dilaudid. She's taking Valium. She's taking Flexeril. And the only way she can actually live without screaming is to take so much medication that she has to put herself to sleep. So she spends her days sleeping or screaming or sitting on a toilet because she can't have a normal bowel movement or normal urination, and this is from the damage from the pudendal nerve that Dr. Jordan did. And these experts it's not a pain disease. That's why his experts were useless.
Sorry, I'm just trying to clarify. And the prescriptions, the pain meds she's taking, who's prescribing those?
Now, it's a Dr. Tolbert, and she's prescribing exactly the same medicines and the same doses that I was prescribing. Okay. Nothing has changed except she needs now much more Flexeril because that puts her to sleep.
I think you've answered the question. Thank you. Are there any other questions from any of the members of the panel? All right. Then with that, we are adjourned, and we'd ask that the audience and the parties please leave the room while we go into closed session. Thank you. We are off the record. We ready? Thank you. We are here on agenda item number 4. Good morning. We are on the record. We are here for oral argument following the Superior Court's issuance of a writ of mandate and remand to the Medical Board in the matter of Mary Ming Zhu, MD, Medical Board, case number 12, 2008, 191190. My name is Beth Faber-Jacobs. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to sit with the board and preside over today's proceedings. Today is October 24th, 2013, and it is about 10:20 a.m. Counsel, may I have your appearances for the record, starting with the complainant, please?
Good morning, Your Honor. My name is Josh Tompley for the complainant.
Sir, and is the microphone next to you?
I believe so.
Can you repeat your name for the record, please?
Josh Tompley, Deputy Attorney General for the complainant. My last name is spelled T-E-M-P-L-E-T.
Tomplet? Is that how it's pronounced?
It's poor French, Tompley.
Tompley. Oh, right. Thank you, Mr. Tompley. And second, please. And counsel for respondent, appearances, please.
Stephen Bassoff, it's B-A-S-S-O-F-F, representing Dr. Zhu, who is present.
Thank you. Before we begin, there's a few things I'd like to share about my background and about my role in these proceedings. Mr. Tomplay is with the Attorney General's office. I would like you to know that for many years, I was a Deputy Attorney General in the Attorney General's office, and for many years was in the Health Quality Enforcement section that Mr. Tomplay is in, although I have never met Mr. Tomplay before. And I also represented the medical board, but did not meet the panel members that are here today until this morning. I have not spoken to any members at the Attorney General's office or the board about this case at all. And I would like to emphasize that I have a very limited role in this proceeding. I am not the decision maker. The board will be making the final decision in this case. There may be some legal issues that arise that I will rule on. I believe I can be fair and impartial and provide a fair proceeding to all parties. But I wanted to share this information before we proceeded. Are we ready to proceed?
Yes, Your Honor, and we have no objection to your hearing the matter.
Thank you. And sir, I'll ask also that you speak up, because if I'm having difficulty hearing you, I want to make sure it's also making its way to the record. Thank you.
Okay. May I begin?
Well, actually, I just want to emphasize that you know our time limitations, 15 minutes and 15 and 5 and 5. And I will be keeping time. Would you like a 2-minute warning when you've got 2 left?
Yes.
All right. And you also know the limited issue that is being addressed today?
Yes.
All right. Then with that, yes, sir, you may proceed.
As Your Honor indicated, the remand notice that we received concerned, I guess two issues. One particular client BC. We believe, as you review the record, and I'll try not to go over everything that I've written to you, but as the Superior Court judge found, there is insufficient evidence to support finding 34 and 37 with regard to extreme departure from the standard of care. As the record indicates, there were 3 experts that testified at this proceeding. Dr. Benda and Dr. Franklin represented the board. Dr. Capozzoli testified on behalf of Dr. Zhu. Dr. Capozzoli in the past had provided expert testimony on behalf of the medical board. With regard to BC, there were 2 findings of extreme departures from the standard of care. One concerned that Dr. Zhu did not treat or acknowledge acute coronary syndrome and myocardial infarction. Both of those, there's insufficient evidence to support those findings. The record clearly indicates, based upon both Dr. Benda and Dr. Capozzoli's testimony, that both of those were considered and ruled out by Dr. Zhu, and there really was no basis in the record. It appears that Dr. Franklin perhaps misread the note, but the bottom line is that there was not sufficient evidence to support a finding that Dr. Zhu committed an extreme departure from the standard of care by not considering ACS or MI. Now, with regard to finding 37, there's even less evidence with regard to that. It appears from the record that it is solely based on Dr. Franklin's review of a transcript of I guess an interview that Dr. Zhu had with a medical board physician. However, when Dr. Zhu testified at hearing, it was very, very clear that she knew the impact of nitroglycerin with regard to stable angina, and that Dr. Franklin simply, and her testimony is clear, it's cited in the record, I won't go back to the page, but it was cited in my points and authorities in support of the writ and also cited by the court. Now, the issue that I would like to talk about is the second issue that the board outlined here with regard to the issue of penalty. We believe that the penalty was extreme in 5 years. Dr. Zhu is a very, very good physician. This is her first instance of appearance before the board. She worked in an extremely difficult environment. While we acknowledge that the standard of care is the same, whether you're a physician working in a prison or I guess a physician working in the best hospital in California, the simple fact of the matter is that there were extreme circumstances at California prisons with regard to medical care. I'm not going to go into it, but Dr. Zhu and other physicians were working with a difficult client base with limited resources, so much so that the federal court, as you know, has taken over health care in California prisons. She was working in something that was titled an emergency room, but the simple fact of the matter was it did not have any of the equipment that you would commonly find in an emergency room. It was, as the evidence showed in the record, a glorified, I guess, clinic. And so those were the circumstances under which she was working. In addition to that, she had, it's in the record, she had a limitation based upon the administrators at the California Medical Facility that there was a time limit within which a physician could keep an inmate in the emergency room. And so she did not have the luxury, based upon direction from her superiors, to have them stay in the emergency room for a long period of time. I think the limit was 2 or 3 hours, and you have to check in the record, but there was a limitation. With regard to the other patients, I think there's a misunderstanding with regard to the patients that she was working with at the time, or the 5 patients in question. With regard to patient HH, first, it should be noted that it was only Dr. Franklin who found an extreme departure from the standard of care. Neither Dr. Capozzoli nor Dr. Benda found an extreme departure from the standard of care. But the issue seems to be based upon a misunderstanding of HH's condition. And if you go back through the medical records, there was an assumption made by Dr. Franklin that HH had suffered a heart attack back in the 1980s. I think if you go back through and he was suffering from a coronary artery disease. And the simple fact is that there was nothing in the record to support that. If you go back and look at Dr. Capozzoli's testimony, you will see that he testified that his review of the record showed that HH, and I think I'm pronouncing this right, had an angiogram or something similar to that, which showed no coronary artery disease. So the finding that Dr. Franklin made is that he based his conclusion on an assumption, and there was nothing in the record to indicate that this man did in fact have coronary artery disease at the time Dr. Zhu was treating him. Now, in addition to that, we had 2 experts testify that there was no extreme departure from the standard of care. And I'm not, throughout the decision, there are findings made by the board indicating that where there is a conflict in evidence, there's a question about, not evidence, when there's a conflict among the experts with regard to a finding of whether there was a departure from the standard of care, that it's not entirely clear. And the board found that in those instances they couldn't find a departure from the standard of care. In these instances, with BC and with HH, there was a conflict among the experts as to whether there was a departure from the standard of care and whether there was an extreme departure from the standard of care. So it was unclear in the record. My point with regard to HH is not to challenge that finding, because we can't. The Superior Court sustained it. But my point is to show that Dr. Zhu did not just cavalierly treat these patients, okay? She did not just dismiss them. I mean, there's an impression, I think, at least in the decision, that she didn't give attention to these individuals. With regard to H.H., she did give attention to him. She examined him. She, I think she said she did I think she did an EKG and a troponin level on him and found that he wasn't suffering from either MI or coronary artery disease. Now with regard to J.E., and again, I'm looking at this finding not to attack it, but to explain it. She just didn't, there's an impression that she just let this gentleman leave. That is simply not the case.
Sir,
yes?
you understand that the only issue with respect to the merits that oral argument is supposed to address is BC, that and penalty. And you have, at this moment, you have about 6.5 minutes
Okay.
left.
My point in addressing these findings is to show that Dr. Zhu did treat these individuals. With regard to J.E., there was a question about his neurological function. She gave him a neurological examination and found there was nothing wrong with him. She ordered tests for this gentleman. She did not simply let this gentleman go. I think with regard to penalty, there's a couple of things. Dr. Zhu, as I said, has a long and successful history as a physician. She's also treated hundreds of patients at CDCR without incident. With regard to, and she does not take the board's penalty lightly, nor does she think that she's above this. She has participated in every single point of probation. She has completed every single point of probation with the exception of the length of time. And that's what we're requesting here, a reduction in the length of time. She has demonstrated through the years that she's a good physician. The patients in question, there were 5 patients with regard to this proceeding. None of them suffered any harm. There was no catastrophic or significant result to these patients. They all did not suffer any significant harm. And so what we're requesting, I mean, Dr. Zhu acknowledges that there were some mistakes, and she accepts responsibility. But what we're asking for is consideration in the reduction of the penalty, because we don't believe that what occurred justifies a 5-year probationary period. May Dr. Zhu make a quick comment?
Well, she can, if she's going to say anything, I would have to put her under oath, but because this is on remand, we are restricted to the record from the Superior Court and what occurred at the administrative level, unless someone from the board wants her to do so. But technically, we are restricted to that on remand.
Okay. Okay. So I would just, could I reserve my time?
You still have 4 minutes, sir.
Okay. In going over the, and I just want to make sure that when the board reviews the record, it's very, very clear that she, the diagnoses ultimately that she made for all these patients turned out to be correct with regard to each of the patients. Even though the experts found some shortcomings, her diagnosis at the time of these gentlemen all turned out to be correct. So I think I'll leave it at that, Your Honor.
Thank you very much. You'll give me just one moment. All right, Mr. Temple, would you like to proceed?
Good morning, Your Honor and board members.
Good morning.
The penalty imposed by the board on Respondent is the minimum available under the board's disciplinary guidelines, a 5-year probation term and a stayed revocation of her license. Following the 2011 hearing in this case and the 2012 writ proceeding, there remained at least 4 independent findings of Respondent's misconduct. Under the board's guidelines, any one of these findings, considered by itself, requires a minimum penalty of 5 years of probation. The board's original and minimal penalty remains appropriate and is supported by any and each of these 4 findings. To briefly recap the history in this case, in December 2011, the board adopted as its decision in order the administrative law judge's findings that the respondent had committed the following: 8 acts of simple negligence, including repeated negligence, regarding 4 of respondent's patients, inadequate record keeping as to all 5 of the patients at issue, and 4 instances of gross negligence. Respondent subsequently filed a writ challenging only the latter of these findings, the 4 instances of gross negligence. The Superior Court sustained 2 of those findings and remanded the other 2 for consideration today. The 2 instances of gross negligence in question have no bearing on the minimal and reasonable penalty the board has already imposed on respondent. Indeed, the complainant concedes that these 2 findings should be set aside as unsupported by the factual findings. So setting aside these two factual findings, we are left with ample and alternative grounds supporting the board's imposition of the minimal penalty under the guidelines. Looking at the guidelines, the recommended penalty for gross negligence or repeated negligent acts or failure to maintain adequate records ranges from a stayed revocation with 5 years probation to an outright revocation. So here, respondent has been found to have committed both gross negligence and repeated negligent acts and a failure to maintain adequate records. So let's review the 4 remaining findings regarding respondent. The guidelines provide that a single finding of gross negligence deserves a minimum term of 5 years of probation. Well, here we have 2 such findings. That's 2 grounds for a 5-year probation term. The guidelines also provide that inadequate record keeping alone deserves a minimum probation term of 5 years. Here, respondent has been found to have kept inadequate records. That's a 3rd ground. And further, the guidelines provide that repeated negligence alone deserves a minimum probation term of 5 years. And here, 8 findings of simple negligence support respondent's repeated negligence, and that's a 4th ground. In sum, 4 independent grounds support imposing a minimum 5-year probation term. Now, given the multiple findings of respondent's misconduct, each of which carries a minimum penalty of 5 years probation, the board's decision to stay revocation of her license and to impose only the minimal 5-year term of probation seems exceedingly fair. No lesser term of probation should be considered, and there should be no downward departure from the guidelines. Thank you.
Thank you, sir. Mr. Bessoff, would you like to do your rebuttal?
Yes, Your Honor.
If you'll give me one moment so I can set the timer. Sorry for the technology here. You may begin. Thank you.
I think the point is that these are guidelines. These are not set in concrete. If they were set in concrete, we would need to make a presentation in front of the board. The simple fact of the matter is that these are guidelines, and you are charged with making, an appropriate decision given all the facts and given all the circumstances. And that's what we're asking you to do. You ask about mitigation. If you didn't ask that question, or if you didn't want to know circumstances of mitigation, and you didn't ask a question about penalty, then it would seem to me that there's consideration can be given to not conform to the guidelines. Otherwise, you wouldn't ask those questions. And I think these are circumstances. This is not a repeat offender, but it's also somebody who during hearing readily acknowledged difficulty with the notes. Okay, she readily acknowledged that, and she did not contest that. Again, you have to consider the circumstances, and that it doesn't justify it, but it may in some way explain the difficulty in working at the California medical facility and what was going on during this period of time. So I think that these are guidelines, and again, this isn't somebody who has said, I don't know why they did this to me. you know, they're all wrong. She has embraced the conditions of probation. She's willing to learn. She's willing to improve. As I said, she's completed all the coursework relative to probation. The only thing left now is the 5 years. And what we're asking is consideration in reduction of that penalty. Move away from the guideline. Otherwise, why would we discuss with you mitigation, harm to the public? There's never been any showing other than the general proposition that when a doctor does something wrong, the public can be harmed. There was no specific showing that Dr. Zhu harmed any of the patients. She treated the patients. She believed she was treating them appropriately. That others found that she made errors. You know, that's the way it is. But if you go through the record, you'll see that the experts did not agree on where there were errors. And so, you know, it's somewhat difficult at times to hit a moving target, I guess. But the reality of the situation is that you have the authority to move beyond the guidelines. You have the authority to consider something lesser. And that's what we're requesting here today, that you do use your authority and use your discretion and apply a 2-year probationary period to Dr. Zhu. Thank you.
Thank you, sir. Mr. Temple, would you like to have your 5 minutes rebuttal?
Yes, please.
You may begin.
Thank you. Respondent rejects the penalty imposed by the board, the minimum available under the board's guidelines. Instead, respondent insists that she is entitled to a downward departure from this minimum penalty. But respondent cannot escape the fact that any of the 4 independent grounds require a minimum of 5 years probation under the guidelines. If anything, the findings that the respondent violated the guidelines 4 times over suggests that the maximum penalty, revocation, may be appropriate, or at least a penalty above and beyond the minimum, such as a 7-year or a 10-year term of probation. Inexplicably, respondent instead asks the board to depart from the guidelines altogether to impose a lesser term of probation below the minimum level. I'd also like to remind the board that in this case, as in all cases, respondent will be eligible to file a petition for early termination of probation if she is, as her counsel says, completing these requirements successfully. And she would be eligible to file that petition 2 years after the effective decision in this matter, which would be next month. The board's original and minimal penalty remains appropriate and is supported by any and each of the 4 alternative findings of respondent's misconduct.
Thank you, sir. Are there any questions from any of the panel? Yes, Dr. Levine.
Just to clarify, sir, that Dr. Zhu has successfully completed the prescribing practices medical record course and the PACE program?
Yes, ma'am.
And there's a statement in the record about no CME since 2008. Is that accurate?
If we're going to have the respondent respond, I do need to swear her in. There's no problem with doing so. I'd be happy to. I'm happy to do so, but my instructions have been that we swear in anyone who is a respondent. So let's do it so that we can have the answer. Ma'am, if you'll please rise. Raise your right hand, please. Do you solemnly swear under penalty of perjury that the testimony you'll be giving today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. And if you can answer Dr. Levine's question about your CMEs.
We have, while I was at CMF, the prison, we had weekly CMEs, and I have certificates for that. After leaving CME, I didn't apply for a job because I had these marks on my record. However, what I was doing was preparing for my PACE program at San Diego. Here's a certificate that I have completed 40 CME credits. I've just completed that August of this year, and I'm ready to take the next CME, which I think will be in dermatology. I would like to shore up my knowledge.
Thank you very much.
Are there any further questions? Yes, doctor.
So, Dr. Zhu, since you left the state prison system, have you been working and practicing? And how many hours per week or a month?
I have a wonderful part-time job, which I love. I am in a clinic for the homeless in the Mission District in San Francisco. They're wonderful patients. I started there May 20th of this year. I work 20 hours on the payroll. I work an additional 3 off payroll, partly to make sure my notes are absolutely clear and verbose, and I cover everything. We have online records now, and this facilitates things a great deal, as opposed to our ER sheet in the prison, which was 8 by 11 with my space limited to about 3 inches.
Thank you.
And in between, I've done some locum tenens. I was 3 times in the past 3 years working for the Indian Health Service. I was at Fort McCloskey, northern Nevada, and at Pyramid Lake Indian Reservation, which is an hour out of Reno. The rest of my interim time, I was preparing like crazy for PACE, which turns out to be a second set of National Medical Board examiners. It's their exam that I took. So essentially, I earned my MD twice, and I took it
Doctor,
seriously.
I think you've answered the question.
Thank you.
Are there
Sorry.
any other questions? All right, then this matter is under submission. We are going to ask that the parties and the audience please leave so that the board can go into executive session. Thank you very much. I was asked if we would be announcing a decision in this proceeding. No, the decision will not be verbally announced. A decision will be issued by the board.
Okay, thank you, Your Honor.
Thank
You're
you.
welcome. Thank you, everyone. We are off the record. Are we ready to begin and the recording? Are we ready to be on? All right. So good morning. We are on the record. We are here for oral argument following the issuance of a writ by the Superior Court and the remand to the Medical Board of the decision in the accusation against Joel Barnett Singer, MD. It is OAH case number 2012-100212 and Medical Board case number 16-2011-220456. My name is Beth Faber-Jacobs. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to sit with the board today and to preside over these proceedings. Today is Thursday, October 24th, 2013, and it is about 11:30 p.m., or excuse me, a.m. Counsel, may I have your appearances, starting with complainant?
Judge, can
Deputy-
Excuse me, there is an issue?
No, Judge, I just wanted to recognize another panel member being here, Ms. Shipsky.
Thank you. We have another panel member who's come. Hello, thank you. Welcome. All right, Ms. Simon.
Deputy Attorney General Jane Zach Simon on behalf of the complainant.
Good morning. And for the respondent?
Kathleen Morgan on behalf of Respondent, Dr. Singer, who is present.
Thank you. Before we proceed, there are a few things that I'd like to disclose about myself and to explain about my role in this proceeding today. As you know, Ms. Simon is with the Attorney General's office. I want you to know that I was with a Deputy Attorney General in the Attorney General's office for many years, and for the last several of those years was in the health quality enforcement section with Ms. Simon. We were friendly with each other, although we were in different cities. I have not spoken to Ms. Simon about this case at all. I only met the board members in this proceeding for the first time today, and I have a very limited role in this proceeding. I will not be the decision maker. I am not the decision maker. It is the board. There may be some legal issues that arise. If they do, I will rule on those. I believe I can be fair and impartial and give both sides a fair process, but I did want to give you this information before we begin. Are we ready to proceed?
Yes, Your Honor.
Yes,
Thank
Your
you.
Honor.
All right. Then you've already been advised that each party has 15 minutes and then 5 minutes for a rebuttal, and the specific issues that are to be addressed in this oral argument. Starting with Ms. Morgan, would you like to begin?
Yes. Thank you. I'm not going to reiterate what's in my papers, but what I would like to point out is that public reprimand is the appropriate discipline in this case. And that is based on the Honorable Ernest H. Goldsmith's decision. He was very clear that revocation was unreasonable and grossly excessive. He also found that the Connecticut discipline was a relatively minimal penalty. And it is important to understand that California is essentially piggybacking on the Connecticut's findings and on their discipline. Probation in this case would be akin to revocation. Dr. Singer does not practice in California. He has no plans to practice in California, and he could not comply with any probation terms which would require him to practice in California, or, as the complainant has suggested, take PACE training. And so the result would be he would either have to surrender his license for not complying or revocation for not complying. He does not want to do that. He has no other choice at this point but to be licensed. And a public reprimand would ensure the safety of patients, of people who reside in California. It would also be in line with the Connecticut penalty. The other finding by the Honorable Ernest H. Goldsmith, which must be followed, is that there was no patient harm found or alleged. And that is very important in this case. The guidelines do allow for public reprimand when the circumstances require it. And in this case, what we're talking about were some clinical problems which have been resolved, which did not result in any harm to any patient. I do not feel I need the entire 15 minutes because this is a very straightforward case. Any discipline should be piggybacked onto Connecticut, and what I say by that is whatever the Connecticut Disciplinary Board determines, that should be California's determination. So if they determine that Dr. Singer has fulfilled his probationary requirements, then that is what California should find. They are the agency who is overseeing his clinic and his physician's license, and they are the ones who investigated. So at the end of this, we believe that the appropriate is public reprimand, but if you must issue probation, then it should be on terms to completely follow Connecticut and to allow any probationary terms to end when the Connecticut board ends the probation in Connecticut. Thank you.
Thank you. Ms. Simon?
I also will not reiterate everything that is in our brief. but just to focus on the fact that we are here today to determine on remand what is the appropriate penalty to be imposed in this case in light of the Superior Court's order on remand. It's important to keep in mind that Joel Singer is a physician who, for the past approximate decade, has been unable to consistently practice medicine within the applicable standard of practice in his home state of Connecticut. He has been disciplined by the Connecticut Board 3 times, which has in turn brought him now before this board on his 3rd occasion. The court has stated that revocation of the license, outright revocation, is not an appropriate or available penalty in this case. So the task that confronts this board is to fashion a disciplinary order that, first of all, conforms to the remand order, and second, and most importantly, protects the California public while allowing Dr. Singer to retain his California license under terms and conditions short of revocation. The ultimate decision to be made by this board under the remand order should consider and address, the court has directed the board to consider and address the declaration submitted by Dr. Singer at the January 2013 hearing, including his assertion that he has complied with the Connecticut order and that at some point in time, patients were apparently satisfied with the care that they received from Dr. Singer. The Superior Court has also directed the board to consider a new declaration that Dr. Singer filed at the time of the writ proceeding, which asserts that the revocation of his California license under the board's disciplinary order resulted in the loss of his hospital privileges in Connecticut. Even when considering these additional items that the court has directed the board to consider, the current problems raised by this case are not insignificant. The ambulatory surgery facility that is solely owned and operated by Dr. Singer was found by Connecticut inspection authorities to be deficient in ways which are very basic and clearly go to the issue of patient safety. There was a lack of appropriate nursing oversight. There was a lack of current CPR certification of the nursing staff. There were deficiencies in sanitation and infection control practices. Now, Dr. Singer's brief that was submitted in this case makes the point that there was no allegation or finding of patient harm and goes on to say that the patients were not put at risk. In light of the deficiencies that were found by the Connecticut inspection authorities, it is troubling that Dr. Singer continues to insist that his substandard surgical facility did not pose a risk to patients. Now, the board has also been directed by the Superior Court to consider the potential consequences to Dr. Singer of a disciplinary order. Even with that consideration, it is the board's paramount duty and paramount consideration to be public safety. It is not what is convenient for Dr. Singer and what works for him given his desire to stay in Connecticut and his choice not to come to California to work on a probation if one is imposed. Dr. Singer holds a California license, and as such, he is subject to whatever orders this board deems necessary in order to protect California consumers. Now, keeping in mind the competing objectives that we have here of physician rehabilitation and public safety, this case is simply not one that can be appropriately and safely resolved by the issuance of a 3rd public reprimand. The underlying conduct, as I've mentioned, dealt with Dr. Singer's maintenance of a surgical facility in a manner which again departed from the standard of practice. These were not de minimis violations, and indeed the Connecticut board required a period of probation and oversight and monitoring by that board. It also can't be ignored that, and this was something that was observed by the administrative law judge in the original decision, that past reprimands have not served to ensure that Dr. Singer conforms his practice to governing standards. Under the board's disciplinary guidelines, and in consideration of the unique facts of this case, public protection requires a period of assessment, evaluation, oversight, and monitoring. If we just consider the guidelines for unprofessional conduct, in a case that is not suitable for a public reprimand, and I've explained in our brief, this is not such a case. The minimum guidelines call for a revocation stayed with 5 years period of probation. An education course would be required, a course in professionalism designed to impress upon Dr. Singer that it is simply not acceptable to come before a licensing board every few years with still another example of substandard practice or unprofessional conduct. Dr. Singer should be evaluated by PACE or an equivalent program to determine whether he is capable of practicing within the standard of practice, and he would require a practice monitor. The guidelines also suggest a no solo practice provision. I think it bears mentioning that Dr. Singer's argument and the premise underlying his argument really misses the point about the purpose of disciplinary action by this board. Dr. Singer may not be practicing in California, and he may not at this point in time plan to practice in California. But he holds a license that authorizes him to treat California patients in this state. To the extent that he has demonstrated that he has engaged in unprofessional conduct or violated provisions of the Medical Practice Act, it is this board's responsibility to address the concerns or deficiencies that are raised by virtue of that conduct. And the failure to do so poses a risk to public safety. The issue is not really whether Dr. Singer actually practices in California or whether imposing a period of probation would be inconvenient for him or require him to make choices that he doesn't wish to make. The point is that he has a California license. He has the right and the authority to practice medicine in California, and that's what our disciplinary system and our disciplinary guidelines have been carefully designed to address. So with that, I would submit that a disciplinary order consistent with the board's disciplinary guidelines is both appropriate and necessary and conforms to the remand order.
Thank you. Would you like to do, Ms. Morgan, would you like a rebuttal?
Yes, Your Honor.
5 minutes. You may begin.
The administrative law judge's decision went before a superior court judge. He found it was unreasonable and grossly excessive. The very same arguments you just heard, he said, were no good. In his decision, he said the relatively minimal penalty imposed by the Connecticut Medical Licensing Board. It is not sufficient to say this statute was broken, so therefore he did all these things. Connecticut is the investigating agency. They were the ones who looked at what actually happened. And they are the ones who are monitoring Dr. Singer. They are the ones who have direct knowledge as to the seriousness or relatively minimal nature of the violations. And Honorable Ernest Goldsmith said they determined a relatively minimal penalty was appropriate. What also cannot be overturned in your decision is the fact that the court found that no patient harm was found or alleged. That is in the court's decision. So there cannot be a finding of patient harm, because that would not be in conformance with Judge Goldsmith's decision. I would also like to talk about the concept of rehabilitation. Connecticut is the board who is investigating and determining rehabilitation. When or if they determine that probation is no longer necessary for Dr. Singer in Connecticut, they have to factor in rehabilitation. So therefore, since they are the ones who are in fact overseeing him and actually overseeing his actual practice, not a mythical practice that may occur in some time in the future, but his actual practice, you should take into account their findings. And they will take into account rehabilitation. And there is no reason to believe that they will allow the people of Connecticut to be at risk. And when they determine that probation is no longer necessary, I'm asking that you make the same finding, unless you can find that for whatever reason they are negligent in their duties. And you will not be able to find that. As to the fact of repeated violations, there are no repeated violations. The 2 prior public reprimands were single isolated incidents and have not been repeated. Neither one repeated the first one, and the current allegations are not a repeat of the same violations. Dr. Singer has been able to get his practice in compliance, and he did not repeat them. So by saying this is his 3rd time, this is not a 3 strikes you're out criminal matter. It has no relevance to the current action, which I would also like to point out, Connecticut investigated all three actions were based on incidents that happened in Connecticut, were investigated by the Connecticut Department of Public Health. They've taken into account those instances as well. And there's no reason for California to put more emphasis on something than the actual agency who is investigating these. And that's not to minimize your job. Absolutely, you need to make sure that California people are safe. But you can do that by having a public reprimand against Dr. Singer. He doesn't practice in California. There are no plans to practice in California. If he does, you will know. But it would not serve anything other than to punish him by putting probationary terms on him. And the purpose of this proceeding is not to punish. And that is what it would be if it was anything more than public reprimand. Thank you.
Thank you. Ms. Simon, rebuttal?
Very briefly, there is a great deal of territory between the revocation that the Superior Court judge found to be grossly excessive in this case and a public reprimand. And the territory covered therein is where we are in this case. This is not the most minimal case, and it's, according to Judge Goldsmith, not a revocation case, an outright revocation case. It is a case of general unprofessional conduct based on the action of the Connecticut board, and this board is not supposed to be someone who simply sits back and lets the Connecticut board decide what is best in California. Under our statutes and under our law, the out-of-state discipline serves as a basis for the independent duty of this board to assess and evaluate a case and determine, based on our disciplinary structure and our disciplinary guidelines and the way that this board does its business, what is an appropriate consequence for the out-of-state discipline. Judge Goldsmith's order did not say, nor could it properly have said, that the board is bound to enter an order that is identical to the Connecticut order. That isn't what this case is about. And I would submit that the terms and conditions contained in the board's disciplinary guidelines would address the issues raised by this case.
Thank you. Are there any questions from any of the panel members? Then, if there are not, this matter is now submitted. We thank the parties, and we ask that the parties and the audience please leave the room as the panel goes to closed session. This matter is now